The morning sun had barely cleared the rooftops of our quiet suburban neighborhood when my daughter Emily rolled herself out into the front yard, her sketchpad balanced on her lap, the wheels of her chair leaving soft impressions on the dew-speckled grass. She was humming to herself, a soft, sweet melody that drifted like birdsong through the air, innocent and pure. Emily was 17, fighting both a rare neurological disorder and terminal cancer, and though she had lost her hair and a good portion of her strength, she never lost her joy for life. She filled our yard with homemade garden stakes, painted rocks, and small sculptures of woodland animals she made herself. Every morning she added something new, a ladybug here, a squirrel there, as though she were crafting her own little kingdom. Most neighbors loved her whimsical touch, smiling or waving from their porches, but not Karen. Karen was the head of our HOA, a woman with a bleached blonde bob, a blazer collection that rivaled that of any anchorwoman, and an unshakable obsession with maintaining property values. She had already fined us 3 times, once for the unapproved wheelchair ramp I installed, once for Emily's painted birdhouse deemed excessively colorful, and again for excessive presence of non-standard lawn decor. I had paid the first fine without complaint, replied civilly to the second, and outright contested the third. It wasn't just about the money, it was the principle. I was a federal judge. I had presided over cases ranging from cartel takedowns to anti-corruption probes, and I valued order, law, and decency. But I also knew when rules were being twisted into weapons. Karen wasn't just enforcing codes, she was targeting my daughter. Emily's humming, her brightly painted ceramic frogs, her pink wheelchair with floral stickers. These weren't violations. They were expressions of a young girl trying to live with dignity. But to Karen they were affronts. Things escalated fast after Karen began stopping by in person. One afternoon she marched up the driveway and pointed at Emily, demanding she remove the butterfly sculptures from the flower bed because they were offensive to community aesthetic. Emily looked up from her coloring book, her voice quivering as she said, "They make me happy." Karen folded her arms and replied coldly, "This neighborhood isn't your art studio." I stepped in then, gently but firmly, asking her to leave our property. "You're trespassing, Karen," I said. "This is harassment." She sneered, flipping through her clipboard. "It's a legal HOA inspection." 2 days later she had the local police at our doorstep, claiming Emily had violated noise ordinances by playing loud music. When I pulled up the ring footage, it was just the sound of Emily humming and a few birds chirping. The officers were apologetic, one of them whispering, "She's got a reputation, sir," but we had to follow up. Then came the real kicker. Karen filed a formal HOA grievance requesting legal action for willful and repeated violations of communal standards by a resident contributing to unsafe and deteriorating neighborhood conditions. It was as absurd as it sounded, but she had stacked the HOA board with like-minded lackeys, and somehow the complaint advanced through their internal system. Her newest angle was safety. She claimed the sight of Emily's tubes and medical gear was traumatizing to children, and that her visible disabilities caused mental distress to passing residents. I almost couldn't believe it. Karen presented photos of Emily with 4 lines, arguing she was disrupting the visual harmony of the neighborhood and posed a potential biohazard. It was the most vicious form of discrimination I'd ever seen, and it was disguised as bureaucracy. Still, I kept my identity quiet. I didn't want to fight this through power. I wanted to fight it legally, ethically, and by the book, as any citizen would. We showed up at the community arbitration hearing, where Karen arrived with a smirk and a $500 an hour attorney. Emily sat in her wheelchair, holding my hand, dressed in a sky blue hoodie and a beanie covering her bald head. The hearing was a farce from the beginning. Karen's attorney accused Emily of being an active threat to emotional stability in the community. He cited precedents that didn't exist, using legal jargon in ways meant to intimidate rather than clarify. I objected multiple times on procedural grounds, but the HOA board ignored each one. Then, unbelievably, the lawyer presented a proposal for criminal escalation, claiming Emily's behavior constituted malicious disruption, and requested formal referral to district court with an appended motion to explore felony-level charges. I was speechless. The motion called for the strictest possible application of civil and criminal remedies, and while no sane judge would ever interpret that as capital punishment, the phrasing was grotesquely open-ended, enough to include life sentences or worse. The way it was written, they were implying Emily was comparable to a domestic threat. A dying girl. A child. The room fell silent as Karen stood up, smoothed her skirt and declared, "If we make exceptions for her, We'll be forced to make exceptions for every mentally unstable, unsightly, or disorderly resident. This is about the future of our neighborhood." My blood ran cold. I had seen hardened criminals say less damning things in federal court. That night, I filed a formal complaint and leveraged legal channels to have the case reassigned out of local jurisdiction, citing procedural mishandling, disability discrimination, and abuse of private governance. The board's corruption had created just enough of a jurisdictional mess that a pretrial review was scheduled at the federal level. And that's when fate, or justice, finally turned. I was randomly assigned to review the motion. I hadn't planned it that way, and ethics required me to recuse myself. But before I could, I received an unusual call from the Federal Review Office. Due to a rare procedural quirk, and given the nature of the grievance as being rooted in housing law, the motion fell within my authority and discretion. I didn't hesitate. I formally accepted the case, keeping my name anonymous through Judicial Shield protocol until opening day. Karen had no idea. She strutted into the courtroom in a fitted black pantsuit, flanked by her attorney, confident, smug, prepared to deliver a victory lap. Emily and I entered together, quietly, with my daughter bundled in a knit shawl, for tubes hidden under long sleeves. The courtroom was cold, sterile, and silent. Emily gripped my hand with all the strength she could muster. When the bailiff called the court to order and I stepped out in my robe, the look on Karen's face, when she realized I was the presiding judge, was unlike anything I'd ever seen. Her confidence cracked like glass under pressure. Her mouth opened, then closed. She blinked rapidly. Her attorney shifted nervously, whispering something. I sat down behind the bench and looked directly at her, my gavel heavy in my palm. I said the words slowly, clearly, each one like a falling stone. "This court is now in session to review the civil motion filed by the HOA under the claim of neighborhood endangerment and criminal disruption against my daughter." The entire courtroom was stunned into silence. I continued, voice steady, "Let the record reflect that I will be presiding over this case under full judicial authority. The defendant is my daughter, and the plaintiff is the HOA represented by Karen Lennox." Karen tried to object. She shouted about bias, impropriety, called it an ambush. But the rules were clear. The case had been reviewed and accepted within full bounds of legality, and recusal was not mandatory unless I chose it. I didn't, because now justice was finally in the room. As the courtroom settled, a slow ripple of realization spread across the rows of attorneys, clerks, and spectators. This was no ordinary hearing. Karen, flushed and stiff, was now standing before a federal judge who had not only read her ludicrous filing line by line, but was also the father of the girl she sought to punish. The irony struck like lightning. I saw the panic creep into her eyes as she whispered frantically to her attorney, who now looked less like a confident litigator and more like a cornered rabbit. Emily sat at our table, her breathing labored but calm, her fingers curled into fists in her lap. She looked up at me for reassurance and I gave her a small nod. "Let's begin," I said, my voice echoing through the chamber. "The plaintiff has made some extraordinary claims in this filing, including allegations of criminal misconduct by a terminally ill minor in a wheelchair. I'd like those allegations read aloud, for the record." Karen's attorney adjusted his collar and stammered through the motion, reading the ridiculous charges aloud: repeated violations of community standards, display of unsanitary medical devices, unauthorized emotional disruption of neighborly peace, and most disturbingly, behavior resembling psychological warfare through disruptive visual exposure. I stared at him silently when he finished, then turned my attention to Karen. "Do you stand by this?" I asked her directly. She shifted in her seat, hesitated, and said, "Your Honor, I saw the board and I simply believe that—" "No," I cut in. "I'm not asking about the board. I'm asking you. Do you, Karen Lennox, stand by these allegations filed under penalty of perjury against a disabled teenage girl?" Her face flushed red. "Yes," she muttered. "I do." I opened the evidence file and tapped it with my gavel. "Let's review what this alleged psychological warfare looked like." The screen lit up with photos from Karen's own submission. Emily in her wheelchair holding a paintbrush, smiling as she decorated a flower pot, a wind chime made of spoons and ribbons hanging near the porch, a squirrel sculpture made of twigs and bottle caps beside a bed of tulips. "These are the terroristic acts in question," I said, my voice dry with restrained fury. A snicker erupted somewhere in the gallery, quickly silenced. Karen's lawyer objected on the grounds of judicial conflict of interest. I leaned forward. "Are you alleging judicial misconduct in open court?" He stammered. "And no, Your Honor. Only that the facts are emotionally charged." I nodded. Correct. They are. Because what you've done here, what this woman has done, is weaponize law and policy to target a disabled child with fatal illnesses for the crime of existing. I turned to the court stenographer. Make that part of the record. The next hour was a meticulous dismantling of their case. I reviewed every citation Karen had ever issued to us, exposing how selectively the rules had been applied. Neighbors with Halloween decorations, garden gnomes, and unsanctioned patio lights had never been cited. I presented testimony from 6 neighbors who had each received informal threats from Karen if they didn't vote her way in HOA meetings. One elderly couple even admitted she tried to shame them into cutting down a dogwood tree because it attracted the wrong birds. My personal favorite was a video clip submitted by a neighbor showing Karen photographing our trash cans one Thursday morning while muttering, "They think being sick gives them immunity." I paused the video on her face. "Is this you?" I asked. Karen nodded stiffly. "Do you believe your actions were reasonable?" "I was trying to keep the neighborhood clean," she snapped. "It's my responsibility." I replied, "It is not your responsibility to police the health, disability, or existence of others. Especially not through HOA policy, and especially not in bad faith." The turning point came when I introduced a surprise witness, our mail carrier, a soft-spoken man named Julio. He took the stand and recounted how Karen had tried to convince him to stop delivering packages to our door because disabled people shouldn't be encouraged to be independent. Audible gasps filled the room. Karen's attorney turned pale. "She said that?" I asked. Julio nodded, eyes downcast. "Twice." Karen stood up abruptly. "This is a witch hunt. You can't do this. You're her father." I banged the gavel. "I am also the judge who was randomly assigned to this case through proper channels, and I am conducting this hearing in accordance with federal procedural standards." I leaned forward. "You will not yell in my courtroom." She sat down slowly like a balloon losing air. After a brief recess, I resumed and requested final statements. Karen's lawyer, now thoroughly shaken, attempted to paint the issue as a clash of values, an unfortunate miscommunication, and a neighbor's desire for consistency. I allowed him to finish, then turned to Emily. "Miss Harper," I said gently, "do you wish to speak?" Emily nodded. Her voice trembled but held strong as she said, "I just wanted to make people smile. I know I don't have long. I just wanted to leave something behind that made the world a little nicer." Silence. Everyone in the room sat stunned. I watched Karen shrink into her chair, her lawyer resting his face in his palm. Then I gave my verdict. This court finds the plaintiff's case to be without merit, malicious in nature, and in violation of multiple federal statutes protecting individuals with disabilities. Furthermore, I am initiating a referral to the Department of Justice for potential civil rights violations and abuse of governance. I looked at Karen. "Your behavior was not just inappropriate. It was cruel, bigoted, and criminally negligent." I turned to the bailiff. "Escort her from this courtroom. Her conduct has violated the dignity of this institution." Karen stood up, red-faced, muttering, "This isn't over." But it was. The moment the doors shut behind her, I looked at my daughter, who was crying softly now, and stood up. I walked around the bench, crouched next to her, and wrapped her in my arms. The courtroom rose to their feet, not out of tradition, but in respect. In that moment, we weren't just judge and defendant or even father and daughter. We were two people who had faced the worst kind of malice and come out with dignity intact. As we exited the courtroom, reporters gathered outside, microphones already aimed. I held up a hand and said, "This wasn't about power. This was about principle. My daughter did nothing wrong, and today the law did what it was always meant to do, protect the innocent." That night, our yard glowed with lights and flowers left by neighbors. Cards and painted rocks decorated the fence. Someone even tied a butterfly balloon to the mailbox. Emily smiled wider than I'd seen in months. And though the battle had shaken us, I knew something had shifted. The world, even if just a little, had turned our way again. The weeks that followed the courtroom showdown with Karen were filled with a strange, humbling peace. For the first time in months, our neighborhood breathed freely again. No one checking over their shoulder for citations, no silent judgments from porch steps, no manufactured complaints about porch plants or wind chimes. Emily, though still weak from her treatments, began spending more time outside. Neighbors stopped by almost daily, bringing hand-painted flower pots, baked goods, and cards. Children from the cul-de-sac came to sit on the grass near her wheelchair and paint rocks together. What Karen had tried to destroy, the community now rebuilt stronger. But even in that comfort, I knew the case was far from over. Because what Karen had done, Using her position as HOA president to inflict personal torment wasn't just immoral, it was illegal. My ruling in court had barred her from further action, and the DOJ's Civil Rights Division had opened a formal investigation. But the deeper I looked into it, the more rot I uncovered. Karen's war on my daughter wasn't isolated. It was part of a years-long pattern of abuse masquerading as HOA policy enforcement. She had evicted a widower over a missing fence slat. She had fined a young couple nearly $7,000 over inconsistent mailbox fonts. And she'd threatened a family with foreclosure over a backyard trampoline, visible from the second story. Now, armed with fresh evidence and the full backing of a federal review, I initiated proceedings to have Karen removed not just from the HOA board, but from any position of community governance permanently. The federal complaint drew national attention. News outlets picked up the story. Interviews aired. The footage of Emily testifying, shaky but defiant, spread like wildfire online. And then one day an unexpected letter arrived at our door. It was from Karen herself. A full page, handwritten, erratic in tone. She insisted she'd been misunderstood, that she only wanted standards and respect for rules. She accused me of using my position as a judge to stage a takedown, and even went so far as to say Emily's illness was a manipulative distraction. That letter was her final mistake. I submitted it directly to the DOJ investigators. The words manipulative distraction sealed the deal. Within a week, Karen was indicted on multiple counts: abuse of governance, civil rights violations, harassment of a vulnerable person, and obstruction of justice. When federal agents came to serve the warrant, she resisted, screamed in her driveway about how the sick girl's daddy was ruining her life. The neighborhood watched, stone-faced, as she was placed in cuffs and led away. But the story didn't end with her arrest. Our HOA, broken and mistrusted, had to be rebuilt from scratch. I helped organize an emergency election to replace the board, and for the first time in years, residents turned out in overwhelming numbers. A retired school principal was voted in as the new president, compassionate, level-headed, and fair. Together, we rewrote the bylaws that Karen had once used as weapons, adding strict anti-discrimination clauses and an oversight committee to prevent abuse of power. And then, something remarkable happened. Emily, frail but determined, asked to speak at the first new HOA meeting. Dressed in her soft blue hoodie and with a feeding tube still tucked beneath her blanket, she wheeled up to the front and took the mic. "I never asked to be sick," she said simply. "I just wanted to plant flowers and paint little things. I didn't want to be a symbol. But now that I am, I hope it reminds people that rules aren't more important than kindness." There wasn't a dry eye in the room. Her words didn't just heal a community, they ignited something far bigger. Within months, Emily's story was being taught in seminars on disability rights and HOA reform. She was invited to speak via video call at a national housing conference. And though her health continued to fluctuate, each day brought a new sense of purpose to her life and to mine. Then, in a move that shocked many, the Federal Judiciary Ethics Board reviewed my conduct in the case, not out of wrongdoing but because of the public visibility. They concluded I had maintained appropriate conduct, transparency, and impartiality throughout. But I made a personal decision after that. I stepped down from the bench voluntarily. Not in disgrace but in peace. I'd fought the most important battle of my life, not just as a judge but as a father. And now, I wanted to be more present for whatever time I had left with my daughter. We took a trip together, just Emily and me, to the redwood forests of California. She'd always wanted to see trees that felt older than time. We wheeled along the soft forest paths together, the sunlight filtering through like it was made of gold. She touched the bark with reverence. "They feel like they've seen everything," she whispered. "They have," I said. "And now they've seen you too." Back home, a new mural was painted on the HOA clubhouse wall, one designed by local kids under Emily's guidance. It featured a giant tree whose branches were made of paintbrushes, crutches, wheelchairs, and books. Birds flew from its top, carrying ribbons with words like compassion, courage, and change. And beneath it all, in Emily's careful handwriting, was a quote: "Don't be afraid of what makes you different. That's probably the part the world needs most." Karen, meanwhile, faced trial. Despite pleading not guilty, the evidence was overwhelming. Neighbors testified. Video and written records were airtight. In the end, the jury convicted her on all counts. She received a multi-year sentence, a lifetime ban from HOA positions, and mandatory rehabilitation counseling. Emily never gloated, not once. "I don't want her to suffer," she told me. "I just don't want her to hurt anyone else." And that's exactly what the law ensured. The final chapter came on a quiet afternoon. Emily and I were sitting in the garden when she looked at me with tears in her eyes, not from pain but something deeper. "Dad," she whispered, "you didn't just protect me. You showed everyone who I really am. Thank you." I couldn't answer right away. I just pulled her into my arms and held her, surrounded by the flowers she'd grown, the stones she'd painted, and the neighborhood she'd helped heal. No gavel, no bench, no courtroom could have ever made me prouder than that moment. And though I once wielded the law to render justice, I learned that sometimes, justice looks like a wheelchair under the sun, and a girl brave enough to change the world just by surviving in it.